And good afternoon. I'm Julie Rendelman. I'm going to be your host for the next 2 hours. I'm going to try to live up to Mr. Bianchi's talents. You're going to be hearing more this afternoon about the case, an old case from 2015, the penalty phase of Florida v. Colley. And if you want to look on Law&Crime online, you can check out South Carolina versus Moore, which is a kidnapping case, which is incredibly riveting as well. But for now, you're just going to take a look at the afternoon top crimes with Anthony Velez.
Here are today's top crime stories trending on lawandcrime.com and across the country. Famed Gone with the Wind actor Olivia de Havilland is asking the U.S. Supreme Court to overturn a California ruling giving FX the okay to use her persona and name in a show. Her attorneys contend de Havilland was never asked for permission to use her likeness in Feud, Bet and Joan, a mini series about Bette Davis and Joan Crawford. De Havilland argues FX and producer Ryan Murphy are making reckless or knowingly false statements about a living public figure, and the ruling in California is a radical departure from traditional First Amendment interpretations. It is unclear what de Havilland is seeking in damages. A man in Missouri out on probation was arrested after he posted a video to Facebook showing how to remove his ankle monitor, which he is legally required to wear. 33-year-old Dustin Burns allegedly recorded an instructional video on how to remove the device.
This is how you take an ankle bracelet off without breaking the circuit.
Burns now faces a felony count of tampering with electronic monitoring equipment. Disgraced former Congressman Anthony Weiner, who is serving a 21-month prison sentence for sexting with a 15-year-old girl, will be released early for good behavior. Weiner, a once prominent New York Democratic congressman who resigned in 2011 following the release of sexually explicit text messages he exchanged with women other than his wife, is serving his sentence at the Federal Medical Center Devens in Massachusetts. Weiner is now scheduled for release on May 14, 2019. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
And I'm here with Francey Hakes on Skype. Welcome. Thank you for being here.
Thanks for having me, Julie.
And so one of the things I think they were talking about that Mr. Velez was talking about was the Anthony Weiner case, and we see that he is getting out of prison early. And one of the things I think many of the viewers don't really understand is the idea of registering as a sex offender. So maybe, I know you have a lot of experience in regards to this field, maybe you want to just tell the viewers a little bit about what Anthony Weiner is going to be looking at now that he's getting out of prison.
Well, Julie, the National Sex Offender Registration and Notification Act, known as SORNA, requires every state to have a sex offender registry and to designate sex offenders into tiers, tier 1, tier 2, tier 3, depending on the seriousness of the offense. So Weiner will be designated with a tier, and according to that tier, he will have to register as a sex offender for a period of time, which means regular check-ins, and it could mean things like polygraphs or plethysmographs. He'll have to report to a probation officer for a period of probably some years. He won't be allowed to have contact with children other than his own. Even visiting with his own child may require supervision. It depends on the different provisions under whatever probation he'll be serving.
I was going to say, he could also, this, as you said, this could also have a big impact on his ability to see his own child. So, you know, we're going to go back into, we've been talking about the Colley case, and I know before I came in, the jury came back, and they came back with a guilty verdict for murder. This was a case in which Mr. Colley was convicted of the murder of his estranged wife and his wife's best friend. And now we're going to start to look at the death penalty sentencing phase. And so now we're going to hear from, we're going to get the opening arguments from the prosecution. And welcome back. We're following the penalty phase of the Florida v. Colley case, and we're now watching the prosecution's opening statement. And one of the things I noticed is that she had indicated that she's not going to kind of reinvent the wheel. She's not going to talk about those things that everyone knows about already. Instead, she's going to focus on those things that are relevant to death penalty, which are the aggravating factors to allow the jury to make a determination. I have a special guest via Skype, Francey Hakes. Thank you again for being here. Tell me, I know we watched this trial from beginning to end, and one of the things I noticed, I know, some of my other colleagues noticed, is how organized and methodical the prosecution was in this case. I don't know if you took note of that as well, which is not always the case in many of these situations, especially in these murder cases.
No, you're absolutely right, Julie. I mean, it's a death penalty case, so of course they want to be methodical about it. They've already gotten a guilty verdict through the guilt-innocence phase, and this is the penalty phase. I'm a little bit struck at the prosecutor's tone here. It is a death penalty case, and while you don't want to be accused of simply inflaming the jury's passions, you definitely want to remind them at every chance you get that this was a horrific murder and that the ultimate penalty is the only one that makes sense here. And to do that, you do have to get a little passionate.
Right. It's funny that you say, look, I'm known to be a little outspoken, and I agree with you. I think that there is a level of dispassion. Now, I think that you have to kind of balance it. And so I think one of the things I would agree with you is this is not the only time we saw her a bit too dispassionate. I think she was like that throughout the whole trial. And so I agree with you. We would like to see a little bit more. Although I don't know that we saw it on any side in this case. It was kind of dead in terms of passion.
I think you're right. And the facts here are so egregious. I mean, he was basically hunting down his estranged wife. He murdered one of her friends in a closet. I mean, this is a horrific murder case. And you're right. It was a little dispassionate all around for me.
So, I wanted to just let you know that at 5 o'clock, it's going to be Aaron Keller, my favorite friend of all, is going to be doing the daily debrief. It's going to be at 5 o'clock, so let's take a look. And welcome back. We're watching the sentencing phase of the Florida v. Colley case. And I have a special guest with me, along with Francey Hakes, who couldn't resist. I think he couldn't stay away, probably because I was hosting, and he was upset that I complimented Mr. Keller. Our own Bob Bianchi, thank you for being here.
My pleasure.
And so I guess the question I have for both you and Francey, which is something you were talking about earlier, was, you have a defense attorney who kind of opens initially on some kind of argument that he was too intoxicated to kind of form the intent. And so my question is, has he lost credibility now that we're at the sentencing phase, because he's kind of now expecting the jury to listen to him when he's talking about the fact that he had a really good job, or that he never lost his job? What are your thoughts about that?
I said earlier that I believe that trying to prove a defense in your opening statement that you don't put witnesses on to prove during the guilt phase is problematic in my mind. That said, having tried death penalty cases as a prosecutor, I know the jurors take this very, very seriously. So while I don't think it's clean, I don't think it was detrimental. The case is overwhelming, and obviously what the defense wants to do is to pull on some heartstrings about the kid, about the family, about the collateral consequences, that he lived an otherwise good life. Julie, this is the reason why I think they were bringing out those text messages, the defense, during the defense case, to show he's not a monster and an animal. He's trying to make it work out. He was trying to rehabilitate. But, boy, he's got a lot to come over with 2 dead bodies and the premeditation that was in the case. So he can try the best he can to keep him alive, but it's going to be hard.
It's, and I go to you, Francey, because one of the things you were saying is how dispassionate the prosecutor was. And so let's now talk about the defense, because I think he is, I've never, robotic would be, an understatement in terms of how he has been presenting himself. And, I do wonder if the defense has lost credibility, just because, to me, I think that if I were the defense, I would have hammered home during the case that he had done it, but that, this is kind of crime of passion situation, and therefore you want to cut him a break. Kind of what are your thoughts? And you can agree with Mr. Bianchi, or you can choose not to, whatever your choice is.
Well, I often disagree with Mr. Bianchi when I watch, but in this instance, I have to say I agree with him in that jurors really take their job seriously when it comes to trials and in general, but especially in death penalty cases, the penalty phase is an especially hard time for the jury because they're weighing a man's life, and that is a heavy burden that they carry. And so I think the defense is probably calculating that a little bit of dispassion at this point might work to their advantage. That is, trying to inject some normalcy in it and say Colley is not some kind of raving lunatic that you must take away from the earth, but that he can be really rehabilitated. We don't have to fear him.
I understand. We're going to take a quick break, and then we'll be back. And I apologize for that, but that is the testimony of the deceased sister talking about the devastation of what this defendant left. And I'm here with Bob Bianchi, and I just have a quick question for you: is how does the jury possibly listen to this and feel anything other than wanting him to get the death penalty? I mean, it's impossible. It's extremely hard, and the fascinating thing about trial law, especially if you're a prosecutor like you were, Julie, is that I try to tell the victim's family at the end of the day here, even if the death penalty is what's given, there's a sense of relief, but in the end, it doesn't make it right. And these murder cases destroy the lives of the people left behind, and it's really a hard thing to watch. I've seen families go into, members go into alcoholism, suicide. They kind of felt like the justice system was going to solve their problem, and in the end, it was a hollow victory in a sense. So we have plenty more to talk about, but we're going to watch now the forensic psychologist who's going to talk a little bit about Mr. Colley. And you're listening to Mark Mills, who is, I believe, the forensic psychologist that was called to testify in the sentencing phase. And we are here with Francey Hakes and also Bob Bianchi. And Francey, I think you know the doctor that's testifying. Is that correct?
I do. Mark Mills is a friend of mine, very smart man. He is an MD and a PhD.
So now that you know him, if you're able to be in any way to separate yourself, my question that we were talking about at the break is, when I listen to this story about Ambien and its impact, my position is that this means nothing and that no jury's going to buy it. What are your thoughts?
Well, I think it's interesting. I certainly disagree with what Mark is talking about in this trial, because you don't become a murderer because you're taking medication. You don't become a murderer because you're drinking. It may lower your inhibitions, but you don't become someone you're not because of medication.
And Bob, what are your...
Well, I as a prosecutor would argue that that's no way that would take over for this scenario, and I'd be seeking the death penalty. But that said, there are medications that are out there that clearly, I don't want to mention them by name, but I have seen them where it says could cause violent activity, could cause suicidal thoughts. And if you're a person who's on the edge and some traumatic thing happens and you're agitated, but for that medication you wouldn't have done it, I think in 50 or so years from now we're going to learn more and more that these medications are having a substantial impact. Whether to justify not giving the death penalty,
the problem I have is that his actions were so deliberate, methodical, thought out.
Yeah,
and
but it's not saying that he's like mentally ill, deluded. He didn't know the difference between right or wrong. That would be the definition for insanity. What I'm talking about is it lowers your inhibition, say, in a way that the medication that I was given didn't have any synergistic effect, but it said it may make you a violent person.
But my impression from what I'm hearing is that there's even an argument to be made that potentially the defendant in this case doesn't remember a lot of the things he did, and that's what they opened on.
Well,
Julie, that's a crock of
with all due respect, I mean, I get what you're saying, but Ambien has been shown. People have woken up and been like, I don't know how I got to my pool from sleeping in my bed. I don't remember driving in the car. And these aren't people who got charged with crimes. These have been statistically relevant enough that it's in the literature. So who knows? I'm not saying it overcomes this defense, because clearly he wasn't delusional. He was very methodical and planned out, no question.
Yeah,
and Julie, one quick thing. Wandering around in a fog and not remembering how you got somewhere is one thing, but you're not stalking and murdering people methodically and you're on Ambien.
Yeah.
That makes no sense to me.
Absolutely. And remember, this case is a little strange because they opened on it in the original trial and did nothing with it. And so for me, the jury now to be hearing about this seems kind of to be not sensical, because it's still unclear to me why they never brought it out initially at the original trial.
Well, Julie, that's a great point. And that was a defense, in my opinion, mistake or faux pas. But it gets to the point why ultimately I became a person who prosecuted death penalty cases that came against the death penalty.
Right.
Because I was involved in too many cases where defense lawyers were making mistakes that I was taking advantage of as a prosecutor, legally taking advantage of. And I had to get to a point where I'm saying, wow, should the difference as to whether somebody gets executed be because their lawyering is poor?
Look, we were talking about this before, and one of the things I said is, as a New York prosecutor, when death penalty was on the table, the biggest concern I had was that there was politics involved. And the minute you have politics involved in anything, there's a question about, when you're doling out the decision about who should be getting the death penalty and who not, and politics plays a role, there's a problem for me. And that was always the issue I had in making a determination as to who warranted it and who didn't. So we're going to take a break, and then we'll be right back. And welcome back. We're here discussing, we're seeing the sentencing phase of the Florida v. Colley case. And I'm here with our own Bob Bianchi, as well as via Skype we have Francey Hakes. And, we've been talking a little bit about this issue of the Ambien being used, and we have Mark Mills, a forensic psychiatrist, who's kind of discussing how that would have impacted the defendant such that the jury should save his life. And one of the things that I admit that I can't stop thinking about is that I believe that the defense blew this case from beginning to end because I believe their tactic was all wrong. And I guess the thought I always had was that they should have argued that they should have kind of owned that he killed this person and kind of explained the nature of a relationship and what it feels like to be left, kind of thing. You disagree with me about that?
No, I've been saying all along that I think that the introduction of the way they went about the case left a bad taste in the juror's mouth because they didn't prove that in the guilt phase, and that could have a synergistic effect when they go into the penalty phase. So I think, though, that they're doing what they should be doing right now, which is putting on mitigation experts, because, as you know, anything that a defense can put on that mitigates life versus death, they're allowed to do, and alcohol and drug intoxication is one of those things.
Even one jury. Even one juror. So we'll be back in a moment. This is Law&Crime.
Disgraced former Congressman Anthony Weiner, who is serving a 21-month prison sentence for sexting with a 15-year-old girl, will be released early for good behavior. Weiner, a once prominent New York Democratic congressman who resigned in 2011 following the release of sexually explicit text messages he exchanged with women other than his wife, is serving his sentence at the Federal Medical Center Devens in Massachusetts. Weiner is now scheduled for release on May 14, 2019. Those were today's top crime stories. I'm Anthony Velez for Law&Crime.
There's nothing like removing your ankle monitor while you're filming it for the world to see. So we thank him for that. Anthony Weiner is getting out of jail. And so let's just talk about it for a moment. He's getting out on good behavior. Bob Bianchi is here, along with Francey Hakes. What are your thoughts about someone being able to get out earlier than than the original sentence that they had?
Well, in New Jersey and in other places, they have a truth in sentencing law that requires a judge to tell the people what the real or actual parolable sentence is. I don't have a problem with it. In fact, there's actually a lot of guards will tell you it's a safety mechanism for them, that if you're good, you're peaceable, you don't hurt the inmates, you don't hurt the guards, you can get out of jail earlier. It's a measured sentence for what this particular guy did. He was in federal prison. He was in the medical ward. He was a danger, I'm sure, all the time. He was going to be a targeted guy. So I see nothing wrong with that concept.
Yeah, and especially, this is a guy who was not in for many months. So, he certainly wasn't going to, it's not like they're lessening his sentence that much more.
A prediction here, the mushroom factor will come into place. And what I mean by that is he will sprout back up into the public arena shortly, mark my words.
Actually, I was going to ask you, Francey, we were talking a little bit about the sex registration. How does that work? Does he do that hearing right when he gets out, or what happens? Because one would assume that he can't get out unless there's some type of registration in place.
Yeah, let me say first that Anthony Weiner is extremely lucky that he had a light prosecutor, someone who wasn't going after the charges that they could have gone after, because enticing a child under federal law carries a mandatory minimum penalty of 10, and all he pled to was an obscenity charge, so he's super lucky. He was at Devon's, which is the sex offender treatment prison in the federal system, so he got credit for doing some of that sex offender treatment. With respect to registering, there's not any kind of hearing. He will simply have to sign an acknowledgement that he understands the sex offender conditions of his supervised release. He'll be on supervised release for a period of time. He'll have to report to a federal probation officer, and that may include doing things like checking in on where he's working, where he's living, is he near a school, what children is he allowed to be around, all sorts of conditions. There's usually about 5 pages of sex offender conditions for federal parolees or for federal probationers, really. So he'll be under some pretty strict supervision.
Right, and who determines what level of registering he is?
Well, it's a federal crime, so the Sex Offender Registration and Notification Act will determine that. He's probably the lowest offender under Tier 1, 2, or 3. He's probably a Tier 3 offender because the charge was an obscenity charge rather than an enticing charge. So the term that he'll have to be a registrant under the Sex Offender Registry will actually be a lot less than it could have been.
Right, because if this had been a situation where he'd actually met the child and actually had engaged in physical contact, he arguably would have had a higher registry. Is that fair to say?
It is. Well, if he had been charged with enticing a child, which is conduct he actually did,
sure,
he would have been a higher tier offender.
Got it. All right, so we're going to throw back to the Florida v. Colley case. And I think we have Mark Mills still on the stand. He's the forensic psychiatrist that is talking about the defendant's use of drugs and how those drugs may have impacted his kind of decision-making when it came to the death of these victims. Here. And welcome back. That's Mark Mills. He's the forensic psychiatrist who is testifying on the sentencing phase of the Florida v. Colley case. I'm here with Bob Bianchi and Francey Hakes. Thank you for staying on. You are quite a dedicated member of the law and crime community, and we thank you for that. You know, the question I have is, what is the jury's take on a forensic psychiatrist? Now, you know, Francey knows the doctor, and he seems absolutely brilliant. One wonders if some of the language might be lost on a jury because it might be above their heads. But, you know, what is your take on kind of what they're taking in and how it's impacting their decision-making?
In order to understand where the forensic psychiatrists and psychologists that are testifying in death penalty cases fit in, you have to remember that the jury can only find death based on aggravating factors and weighing of mitigating factors. And in most places, the mitigating factors are slanted in favor of the defense. That is, the prosecution's set to a limit of them, but the defense can have a number of them and then a catch-all, whatever else they think is relevant. Right. And that's where the psychiatrist is fitting in. He's saying that he was compromised. Okay, you may not think it was to a legal point of not insanity, but, you know, intoxication or anything like that. But you could take it as a mitigating factor in that catch-all to say, look, it tends to excuse or justify the conduct in a way not to impose the ultimate penalty, the death penalty. Life in prison for the rest of his life will be more of a torturous thing for him. Please spare his life. That's how these psychiatrists are used in my mind. And
Francey, what is your take on this? I mean, you know, look, he's brilliant. There's no question about it. And he is articulating for the jury kind of not just not just Ambien, but the combination of Ambien along with many of these other drugs that would, again, not excuse his behavior, but at least give some level, just a tiny bit of mitigation as to why it is that it may have risen to the level it did.
Julie, you're absolutely right. Mark is brilliant, and he's also a great communicator to the jury, even though they're throwing out some of these highfalutin terms that there's no way anybody in the courtroom but Mark knows really what they mean. Still, they sound great. And you have to remember, the defense is targeting one person. The defense isn't really targeting 12. The defense doesn't need to get all 12 to agree the way the prosecution does in order to impose the death penalty. They only have to get one who says, well, you know, that Dr. Mills, he sure was convincing, and it was out of character the way Colley was acting, and so I don't think he's really that much of a threat. I don't think he represents a danger, and I just can't put him to death. Just one. That's all it takes.
Such a great point. So, you know, Aaron Keller, prosecutor is going to be doing the daily debrief. It's going to be coming up after the show. It's at 5 p.m. And so hoping you can all tune in to watch. But right now we're going to take a break. So that's Dr. Daniel Buffington. He's saying that the defendant was substantially impaired at the time that these crimes occurred. I'm here with Francey Hakes via Skype and Bob Bianchi. And I guess the question I have for both of you is, it seems to me that the doctor's testimony is relying solely on what the defendant tells him he was taking. And so therefore, there has to be some level of suspect in terms of, whether or not the defendant was truthful as to what he was taking, because he has the most to gain by not being forthright about this to try to make it seem like he was impaired. What are your thoughts?
I don't know what evidence they used or didn't use, but if it's based solely on the defendant's account, which is done many times, it's a term we call malingering, which a cross-examination by the prosecutor should be. It's the over-objectification of certain factors, sequelae, that would assist him in a legal context, and that therefore you would just have to estimate if he's telling you the truth and how much of the truth or how little of the truth, because he knows it can help out. Had a case just like it, a death penalty case, where the guy said he drank so much that he was at a point like 2.9, but the doctor forgot to account for a whole bottle of vodka that he said he drank. When he did that, it was a 0.5 something, so that he had to admit that you can't have a blood alcohol level that high. So it was very easy for me as a prosecutor to say, well, was he lying to you a little bit, a lot of bit, or in between? And he couldn't answer. And
Francey, I mean, it seems like it'd be such an easy witness to cross-examine, because all you need to ask him is, everything you're saying is based on what the defendant, who killed 2 people, is telling you.
Well, and more than that, Julie, it's also asking him how many other people in this country and in the world at large are taking Ambien, and how many of them engage in this methodical execution-style murder of 2 people. This isn't even a homicidal rage. This was methodical execution of 2 women. How many people on Ambien do that?
Ambien, Oxycontin, and we see it all the time, and we don't see the brutality that we saw here in this case. And so we're going to be coming back in just a moment. This is Law and Crime. Thank you so much for being here. And that was just the closing arguments by the prosecution on the sentencing death penalty phase of Florida v. Colley. I'm here with Francey Hakes. I know we talked earlier about the fact that the prosecution and the defense seemed a little mellow. I don't think that this prosecutor got any more excited than his predecessor when it came to trying to convince this jury of the ultimate decision, which is the decision for death.
No, you're absolutely right, Julie. I mean, that was very dispassionate. It makes me wonder if that was maybe the open close, and the rebuttal has yet to come, where they're going to get sort of hellfire and brimstone, which is what I would expect to see in a death penalty case. I mean, you're certainly not playing on the jury's emotions, right, but in order to make the jury feel the loss, you have to have some passion. There needs to be some idea about speaking for the victims in the voice that the defendant stole from them. I don't understand why we didn't see any of that, but maybe that's in rebuttal.
Yeah, and we will see. Look, sometimes this is the tactic the prosecutor takes because they think that the evidence, in a sense, speaks for itself. And I think one of the biggest pieces of evidence in terms of the aggravated factor is the breaking of the injunction, because that is something, especially as a woman, that is so terrifying to think about, that he violated in such a degree that he ended up killing these 2 completely innocent individuals. So we're going to be taking a break. When we come back, we're going to see some more of this case. Thank you for being here. And the jury has spoken. They have sentenced the defendant to death. They've all agreed about the aggravating factors. I want to just bring in Francey Hakes before we part. When I think about this case, I think about the fact that there's 2 children. I think there's 2 children that have lost a mother, and now they're going to lose a father. And so I think that the end result means that there's no winners at all in this case. Tell me, what your immediate thoughts when you hear about this sentence of death.
Well, certainly this is a case where if ever there's a death penalty merited, it's this one. I mean, he stalked and murdered his estranged wife and her best friend in what was just a brutal series of crimes after he was under a restraining order, because she was afraid of him already. So it's a brutal crime, but you're so right, Julie, that there's no winners in a case like this, because you're talking about children, family, and friends who've lost the mother and now the father. Nobody wins in murder cases. Even the prosecutors don't feel great about it. They feel like they've done justice, but that doesn't mean they're celebrating.
And it's hard for me because, regardless of my beliefs of the death penalty or not, I think one of the things that troubles me in regards to this case is this was a guy that had not really been in trouble before. And it seems as though something went haywire. And I'm not making any excuses, but he certainly did not behave the way he had behaved at least most of his life. And so, look, no matter what, at the end of the day, I mean, the crimes were absolutely, absolutely brutal. But I am always left to question kind of whether or not the defense could have had maybe a different take that could have brought the jury to a different conclusion. Hindsight is always 20/20. Neither of us were there, and it's always a tough road for the defense. But I can't help but wonder.
No, Julie, that's a great point. And that's something the defense teams agonize over. And, Bob Bianchi said, it was probably an hour ago now, but I just remembered he said something about he took advantage of every legal loophole as a prosecutor. As a prosecutor in serious cases, I actually made sure the defense was doing their job because I always wanted to protect my verdict. And so I do feel like we're having a debate in this country about the death penalty. But in this case, I certainly think it's merited.
Thank you for being here. We're about to do Aaron Keller's Daily Debrief. Enjoy.